Welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello in between. My name is Dan Balkaran, as you see on the screen, and I am going to be your employment lawyer for the next 30 minutes or so, answering all questions that you might have about all things employment law. As you can see, I'm an employment lawyer at Samfiru Tumarkin, LLP, in the firm's British Columbia office. Just a note of housekeeping before we get started. If you need to get a hold of us, you can do so. employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. As always, I encourage everyone to get their questions in now. I will try to get to all of the questions. We have a few that are here. I will try to get to all of them before the end of the broadcast. However, they tend to come in all at the end, and I don't want to miss anyone. So if you have a question, please send it in to us as soon as possible so I can get to it throughout the broadcast. Okay, let's get started. Okay. Question from I don't want to identify this person, so we'll just say a question from E. I'm in Ontario and I have medical conditions that are worsened by my long commute, even though I can perform my job fully from home. Can full-time remote work be considered a reasonable accommodation when commuting aggravates a disability, or can the employer still require hybrid attendance or, I guess, full office attendance? All right, so this is an interesting question. There are layers to it, so I'll just take the layers in turn. So, number one, if your position was hired as a remote position, or you were hired after the pandemic into a position that was always remote, it may be a fundamental term of your employment that you get to work remotely, in which case the employer forcing you to return to the office could be a constructive termination of your employment, depending on what your employment contract says. A constructive termination of your employment is where the employer unilaterally changes a fundamental term of it can be a few things, but in this case, unilaterally changes a fundamental term of your employment that you don't agree with, effectively breaching the contract such that you have been, your contract of employment such that you have been terminated. Now, the interesting thing about constructive terminations is it's effectively the employer's actions terminate your employment, but you are the one you as the employee are triggering the constructive termination by saying, I am construing your actions, employer, as a termination of my employment. So you in effect are firing yourself. And so don't ever do that without general recommendation. Everybody, don't do that without the advice of a lawyer. They're too complicated. They're too hard. If you get them wrong, you quit and you get zero. You want to make sure there's value there to doing it. If there isn't sufficient value, it doesn't make sense to do it. Might as well just work out at your employer while you're looking for another job. So and give yourself sort of self-working notice. So don't ever do it without a lawyer. But could it be a constructive dismissal to force you to work hybrid or remote? It could be, depending upon what your situation was. Now, if you were working at this job from before the pandemic, though, when everyone was really required to go to the office, then it's virtually nil the possibility that you have an entitlement to work remotely. Okay, in which case, by the employer then saying, "Hey, you got to come back to the office," that is not a constructive termination of your employment. If again you were working in that job from before the pandemic. Now, let's talk about the second part of your question. Your commute aggravates your disability. You would have to get a medical note from your doctor saying that, and that's going to be a tough, I don't know what it is, but not all doctors are, I mean, maybe a doctor will write that, maybe not. But if you got medical backing, then it becomes a much more interesting analysis. So is it a constructive dismissal that the employer is not providing you with a healthy work environment for you? I don't think so, but I do think that it potentially violates your your disability entitlements or rights under the, in your case, I don't know the exact statute, but it'll be Ontario human rights legislation. In which case they have to accommodate you, and by failing to accommodate you, if it's reasonable, so if it's a point of undue hardship, then no, or whatever the language is in the Ontario human rights regime. But if you have been working remotely and then just permitting you to work remotely, it may be a failure to accommodate you. That, again, you're going to want to make sure there's value there. I recommend strongly you talk to an Ontario employment lawyer to really run that specific component by a lawyer on the ground in Ontario, because lots of things could go wrong in that. There might not be value. Again, if you need to get a hold of us, you can do so. employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. But in your case, it just depends. Is there, if you can get the medical note, is there sufficient value there through the human rights regime? And I just don't know the answer to that question because I don't practice in Ontario. Okay. Question from Lucky. My contract includes several consecutive statutory holidays over Christmas and New Year's, but my employer withheld pay for all of them because I missed one workday before the holidays due to severe freezing rain and school bus cancellations. Since the day before and after those holidays were also statutory holidays, can they legally do this? No, I don't think so. I think that that's a violation of your rights under the employment standards legislation if you're provincially regulated. And I think that you do have a remedy through your employment standards regime if, again, you're provincially regulated, but assuming you are. However, how much money are we really talking about here? Hundreds of dollars? Is that worth it? Do you really want to? You got to balance, you're upset about this, but, if you bring a employment standards complaint against your employer, chances are you're never going to get promoted and you're probably not going to work there that long. They can't fire you because of this in a relatively, you're protected from reprisal, I would assume, under wherever you are, the employment standards legislation in your province. But at a certain point, that time period runs out, and they're not going to want you to be there if you bring such a complaint against them. And so in such a situation, Lucky, I imagine your resolution here is an amicable one. Talk to your employer, see if you can get them to reach some sort of compromise for this, because if you were supposed to get paid those days, just because you missed one day doesn't mean you don't get paid the other days. And also, it wasn't like you missed the day because you were just calling in sick when you couldn't get there. So, but I think you need to work that out amicably with your employer, because I think the alternative, and there's no value in the alternative. You're going to bring in an employment standards complaint for $400? Probably not. Okay. Sam asks. Sam doesn't ask anything. He's just complimenting us on the broadcast. Yeah. Thank you, Sam, for the nice words. Question from Chen. Can my employer require a doctor's note for every sick day, even short ones? I think you need to take a look at this would be easy just to Google it and find the answer out to the actual legislation in your province. Most likely you're provincially regulated, in which case, what does the employment standards legislation say? I believe in BC, and I'm ashamed that I don't know this off by heart. I believe in BC now, the provincial government has said you don't, for 3 days or something, you don't require doctor's notes anymore, which makes sense to a degree. It puts a burden of cost on the employee to pay for doctor's notes, because for some reason doctors charge for those notes above getting paid by MSP. I have no idea why that's permitted under our medical regime, but also on top of that, all these people getting medical notes for calling in sick for one day are clogging up our healthcare system. So I believe in BC, it's legislated that employers cannot ask for these medical notes, at least for 3 days or something. But I don't want to be quoted on that. But I think if you Googled it, you'd find the answer pretty quickly, and I recommend that you do that in your province or territory. Question from Tom. I was fired right after asking about overtime pay. Could that be wrongful termination? Well, so the wrongful termination arises from, did you get enough notice or pay in lieu of notice for your termination as dictated by your contract? And if your contract is inapplicable for whatever reason, your age, length of service, and position. Okay, that's what your wrongful termination is. And so I can't answer that question based on that. What I can say is, if you were in BC and you thought you had an entitlement to overtime and said, "Hey, employer, I want my overtime," and they said, "You're fired," okay, you have a right under the employment standard. If you're provincially regulated, you have a right under the employment standards um, regime in BC, the Employment Standards Act. You have a right to a make whole remedy, which effectively permits you to get paid from the date of termination to the date of a hearing, assuming that you win on that particular threshold question, which I think you would if your facts are correct. If you were on BC, Tom, maybe the moderator can put my contact on the screen. If you were in BC, Tom, I recommend that, or I suggest you may wish to reach out to me. There's my contact on the screen. That's an interesting one, and I may be able to assist you with that. But I don't know what the employment standards regime in your province, if you're not in BC, permits. But in BC, you'd certainly have a pretty strong case for a significant remedy under the Employment Standards Act. Short answer, no, they shouldn't be able to fire you for that. You may have a significant remedy where you are. If you're in BC, give me a shout. Okay. Jordan asks, hold on, let me just see how many questions we have. Okay. Okay. Jordan asks, my employer changed my job duties significantly. Sorry, guys. Just trying to gauge how many questions I have left in the pipeline, and how fulsomely I should answer each question so I can get to each one. Jordan asks, my employer changed my job duties significantly after I returned from parental leave. Is this allowed? Okay, so you are entitled to be returned into your position or a largely comparable position as a result of going on a parental leave. Okay. However, if you come back and they put you in a completely different position, then your employer has either constructively dismissed your employment and or both violated your rights under the employment or under the human rights in BC would be the human rights code, but the human rights legislation in your province or territory. The easier if this is a maternity leave, harder I think if it's a paternity leave under the human rights legislation, because then you'd have to argue family status, and I don't think that's ever been considered, but nonetheless, I'd certainly be happy to argue that. But this is really just a question of degree, and also what's reasonable, and maybe the employer, you're gone for 10 months and your employer had to find a different way to get your job done, and then brought you back into a comparable position, but some things changed slightly. It's a question of degree, right? Are these fundamental changes? Are they not fundamental changes? So that's one you'd have to go through with a lawyer, blow by blow, in terms of the nature of the changes, and then get to the determination of, was it a constructive dismissal or discrimination on the basis of whatever the human rights protected ground is, and then make a determination. You'd also want to make sure there's sufficient value to trigger a constructive termination. And remember what we said earlier: constructive termination, constructive dismissal is where the actions of your employer, which a unilateral change to your job duties can be if it's significant enough, or it's a hollowing out of your position, or a demotion, etc. All those are the hardest to make out if your pay and title are unchanged. Whether or not there's enough there for you to pursue a constructive termination or a human rights complaint. Those are hard, though. Those are really hard, and unless it's really large, and then you're probably you don't have a cause of action. But if the changes are somewhat small, like, you were working mostly with tier 2 staff, but now you're working with a mix of tier 2 and tier 1, it's not going to get you there. So, but that's a question, for an employment lawyer to look at, in terms of change by change. If you want to get a hold of us, you can do so. Employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. Okay. R asks, my employer has given me a Christmas bonus for the last 12 years. And this last year he didn't, saying nothing about it. What are your rights here? Well, what percentage of your pay is your bonus? And, is it 40% of your pay or is it 2%? And then is it in your employment contract? So if it's in your employment contract and it's an automatic, not so much as a discretionary bonus, then certainly it could be a breach of contract and you might be able to sue for the bonus, but I'm guessing the bonus is not a large enough amount of money to want to do that. I assume it's not in the contract, or I suspect there's a good likelihood it's not in the contract, in which case, is it an implied term of your compensation? Yes, it is an implied term of your compensation after 12 years. However, this is where it comes back down to, is it a significant enough percentage of your pay? If it's 20% or below your total pay for the year, then chances are it's not sufficient for a constructive dismissal. Also, it could be a one-off. It might not be permanent. You might get it next year. And you may have to find out if it was an indefinite change or just this one-off year, like maybe there was a bad year or something. If it's less than 20% of your overall pay, which I'm willing to bet that it is, then chances are you don't have a constructive dismissal, barring other things happening, such as a demotion at the same time. And so if you don't have, why you'd want to trigger a constructive dismissal is if you had a substantial amount of money, severance money coming to you that made sense to do that. However, that's really your only remedy in the situation, is either going after your employer for the bonus if it's contractual, or triggering the end of your employment and pursuing severance as an implied term if it's a significant amount of your significant enough amount of your compensation, again over 20% most likely. Neither of those sounds really appealing, I suspect, if you've been there for 12 years. So really, the answer is probably not much can you do about it, but in practical terms, but you may wish to talk to your employer about it if your employer is someone you can approach about these things and ask if there's a potential to get the bonus. It may be a down year. Who knows? You don't know what the situation is. So I do know, some employers just don't brook any of that discussion. The fellow earlier in this live chat question and answer session, that fellow or individual asked about overtime and was fired. So you got to weigh it against what you know about your employer and should you bring it up or not. But do you have legal remedies? Maybe. I suspect not. But are those legal remedies going to be worth it as against the security of a 12-year job? Probably not. Then again, if your bonus is half your pay for the year, it might be. So, if it's if it's over 20%, talk to an employment lawyer right away. If it isn't, probably you want to end up doing nothing other than maybe saying something to your employer and asking about it. But, only if you think your employer is approachable. Okay. H asks, the temporary layoff considered legally valid if it's not explicitly listed in the employee's contract? There's no legal, if it's not in the contract, there's no freestanding legal right for an employer to place an employee on temporary layoff. That placing of the employee on a temporary layoff is in fact potentially a constructive dismissal of the employee's employment. If it's for 2 days, probably not, but it's an indefinite or unknown in terms of time layoff, then you can trigger your constructive dismissal. Of course, if you get recalled, you're going to have to go back to work because, if particularly with constructive dismissals, if the employer recalls you back to work, uh, and there's no reason why you can't go back to work, such as a hostile work environment, then you got to go. That's the law in Canada. So otherwise, you get zero. So the is there freestanding right? No, but what can you do about it? You can trigger a constructive dismissal. Is that worth it? Uh, um, there's under the Employment Standards Act in BC, for example, there's an automatic termination of your employment for Employment Standards Act purposes. Under the ESA, I imagine Ontario has something very similar. Whether it does so for common law severance is somewhat of an open question that's being fought out right now in the courts. So we may want to wait for that instead, rather than triggering constructive termination. But certainly you can do that. And are they allowed to do it? There's no freestanding right. But as always, the question is, what remedy do you pursue for that? Kitty asks, will you represent someone who worked part-time for a year and a half? It's both a human rights and constructive dismissal. Generally speaking, not to get into, whether I or lawyers at my firm will represent any individual, because that's a case-by-case analysis. I'll just say the representation has to make sense financially for everyone, right? So, if you have a matter that's worth $2,000, it doesn't make sense for the lawyer or for you to pursue that. If the matter is worth $50,000, it probably does, right? And so it just depends on different variables involved in your claim, and there are different causes of action that you might have that all might lead to different potential, we'll call it award or settlement range outcomes, and that can inform, or that does inform to a substantial degree, whether or not a lawyer, either at my firm or anywhere else, will represent you. So I hope that helps, Kitty. How much time do we have? Okay. H is back. Also, to continue the temporary layoff, whether employer must continue benefits during the notice temporary layoff, or are they allowed to freeze them until they recall the employee? You got to check the employment standards legislation in your province or territory. I don't even know the answer to this question in BC. I think that they're allowed to freeze them, but I wouldn't be surprised if in Ontario that they don't have to. But it's a fairly straightforward question. Give me one sec. We're out of questions, so this may be the last question, so we might end a little early today. Oh, there's another one. Question from Mark. I gave 2 weeks notice and my employer told me to leave immediately. Are they required to pay me for the notice period? Yes. You gave your 2 weeks notice. They have to pay you for the remainder of that period of time. If they don't, you have a claim under the employment standards legislation in your province. However, that's not something you can get a lawyer involved for, most likely. But it's something that there are remedies available to you that are self-help remedies through the employment standards regime in your province, assuming you are provincially regulated. Question from Kevin. I get injured at work, but my employer tells me not to file a claim. I assume you mean an occupational health and safety claim, workers' compensation. What should I do? I think that you need to do what you feel that you need to do. If you stub your toe at work, do you need to file a WorkSafe BC complaint, or it's called WorkSafe, but do you need to file in BC, but do you need to file a workers' compensation claim? Probably not. If you throw out your back such that you can't stand and you have no idea when you're going to be able to work, then yes, and so that's something that you've got to think about with this. So that's a decision that you have to make for you in the context of your ability to work and the nature of your injuries in conjunction with your doctor. I certainly can't answer that question, but I think employers' premiums are potentially higher. I don't know enough about this, but workers' compensation premiums are higher, and then so there's an incentive for them to have you not file. But I don't, and I've seen it where employers get mad at employees, and it sours the relationship for filing a workers' compensation claim. Also, if you're out for 6 months and the employer has to backfill, it's a host of problems for the employer. But I don't think how your employer feels should inform that at all. It's whether or not you feel you can work, and or if the working will exacerbate your injury. So talk to your doctor and then make the best decision for you. Krista says, I don't know what she says. Okay. Sorry, Krista, I didn't see any question there. Connor asks, my employer says discussing pay with coworkers is unprofessional. Is that legal? In a lot of provinces, no now. Sorry, let me rephrase that. In some provinces, Google it. There's been a lot of news on it recently. I don't even know in BC because things change a lot and it doesn't come up in my practice. But I believe in BC, employees are allowed to know what other employees make. It's pay transparency. Employers are pay transparency is something that has been passed in a lot of locations to affect more equitable policies or outcomes, so that there's less assumed discrimination in pay. Rowing against that is, from an economics perspective, different employees have different outputs, right? And so the employer wants to, and there are different reasons. So there's different outputs from, some employees are more productive than others, in which case the employer is going to want to incentivize those individuals more heavily. And so how do those two things meet in the middle, where someone who's not as productive finds out that someone who's more productive is paid more and doesn't like it? That creates all kinds of problems for the employer, and so the employer's got to try to sort all that out, and maybe some of that is discriminatory, maybe it's not. But I can see why employers want to frown upon that. But are they allowed to tell you to not talk about it? Depends on your province. I would think, maybe not, but there's no remedy for you, so it doesn't matter, right? The question is, are you going to incur penalty for talking about it with your coworkers? That I don't know the answer to, and I don't know if you're protected from reprisal, and that's what you got to find the answer out to. Because if you aren't, you get fired for talking about it. But if you are, then the employer doesn't have a lot that they can do, although that might sour your relationship with the employer if it becomes known that you're talking about wages with other employees, and the employer asks you not to do that. Okay, I'm just going to go through these really quickly. We're pretty much out of time. So have you seen the increase in human rights, employment standards compliance? What are you going to do about it? Challenge forcing legal intervention. Non-compliance. This is sort of a general question. We're not, my job is to, and our jobs as lawyers is to help individual employees obtain their maximum rights under legislation, common law, et cetera, as a result of different workplace outcomes, such as a termination of employment. It's not to change the law. That's more of a question for your MLA or MP. Krista is back. Best answer I've heard on OHS filing as a human resources professional. I guess she's talking about me. Okay. Thank you. In addition, if it could be something that increases with time, it's worth filing. So she's basically Krista's commenting on what I said earlier about the individual, about whether or not they should listen to their employer who doesn't want them to file an occupational health and safety claim for their injury. And she's just adding her own 2 cents about why you've also got to consider whether or not the injury is going to get worse, right? And that sounds valid to me, but again, that's something you're going to want to chat about with your doctor and then make the best decision for you. So, okay, listen, we're out of time. Thanks for joining us. Again, that's me on the screen, Dan Balkaran, employment lawyer at Samfiru, Tumarkin. in British Columbia. As always, if you need to get a hold of us, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Join us on, I want to say, Monday with Chris Justice. Yes, Monday, January 19th, 1 p.m. Eastern Time. Chris Justice. He will be explaining all things employment law, so don't forget to join us for that. And other than that, these were great questions today. I hope you have a wonderful and safe weekend, and I will see you in 2 weeks at my regular time slot, 10:30 a.m. Pacific time. 2 weeks. Have a great weekend, everybody.